present new evidence at your exceptions hearing? Hi, I'm Alycia Kinchloe, the owner of Kinchloe Law, a family law practice based in the Philadelphia area. Now, an exceptions hearing is a hearing that you get after you file exceptions, which basically means there's something that you did not agree with regard to a master's report and recommendations in a support case. Now, there's also exceptions in custody cases, but we're not talking about that today. Now, when you go through a support case, first you start with a support conference, and then you can have a de novo hearing, which is a brand new hearing, before a support master. At that hearing, the master is going to gather evidence. Usually, in your notice to appear, there is a list of documents that you're supposed to present. You can also supplement that list with additional documents that you think may be important to your case. You can also present witnesses. You can have expert witnesses also present testimony regarding your case. And that may be testimony regarding the other party's ability to work. So sometimes we may see a vocational expert. Sometimes we see other experts, maybe a realtor or someone who's able to give information regarding market value of a house or properties that may be in the name of another person or party to the proceedings. So there are other people who could provide testimony as well. It is also your opportunity to present certain arguments and raise certain defenses. So during that time, if you're going to raise a defense to maybe paying spousal support, or if you believe that maybe the other party is under earning, or if there is a dispute as to whether or not tuition should be something that is actually covered or responsible for you to pay, that is also an argument you can make. For example, some courts will make a finding as to whether or not one party unilaterally enrolled a child or children into a private school against the wishes of the other party. And if that is the case, there is a chance that that other party may not be responsible for contributing toward the tuition expenses. I've had that happen in several cases. So again, these are your opportunities to present all the arguments that you want the master to consider. Now, generally, there are some things that they're going to consider on their own. Generally, in a master's report and recommendation that comes out of Philadelphia, a lot of them will have a list of the deviations. So the statute provides a list of deviations or potential reasons that a master may deviate away from what the guidelines suggest is the appropriate amount of support, either up or down. And so sometimes you'll see in that report and recommendations that they considered those things. However, if it wasn't considered, that might be a reason to file an exception. But generally, even if it's laid out in that report, that may be an argument you want to actually raise, bring to the attention of the master, and present evidence or testimony in support of the deviation. The reason I bring these things up is because sometimes people don't realize how important the exceptions hearing is, because it is your opportunity to present your evidence and present your arguments, and it is effectively the last opportunity you're going to get with that particular case. So once the master makes their recommendation, it goes to a judge to review, and then it is sent back to you to file exceptions. And you will have 20 days from the date of the report in order to file that exceptions. And if you don't do so, the order becomes a final order. Now, once the exceptions are filed, you have to, and I'll just kind of explain a little bit about what goes into your exceptions. In your exceptions, you have to specify what things the master made a mistake on. Now, sometimes people will generalize and just say the master made a mistake and was wrong. That may not be sufficient enough, and you might actually end up waiving your right to make certain arguments because you did not raise them sufficiently in your exceptions. But also being too specific could also hurt you as well, because it may not leave enough room for you to argue additional things. Now, as always, you want to speak to an attorney licensed in your state about the facts specific to your case, because they'll be better able to advise you about what your options are. And this is another reason, what I kind of been speaking about so far in this video, is the main reason why it's important to have an attorney at your master's hearing, because that is your opportunity to raise all these things that a lot of people don't even realize are able to raise or to argue in their case, or even have witnesses present testimony in their case. Because once you file the exceptions and it goes to a judge, you're not able to raise new arguments, generally, unless there's some good cause reason for you to do so, and you're not able to present new evidence. Again, except with an exception of good cause. But very, very rarely will any type of new evidence be allowable or be admissible in the exceptions hearing. They really want to see, what did the master do wrong? What errors did they make? Sometimes there may be an error in calculation just because maybe the system calculated something wrong. I've had that happen. Sometimes a number is left out of the actual calculation formula. Like, for example, it was agreed that there was daycare costs and the daycare costs were not actually included. That is a mistake that can be corrected. But then there are some things that you want to argue that the master may have not considered appropriately. The master made a mistake in finding that the other person was not under earning when there was enough evidence to prove that it was. That might be something the judge will want to hear. But it's very, very important for you to understand the gravity and the importance of that master's hearing and to get all those things in. So I hope I drove that home. Hope I'm not being a dead horse here. I just really want to make sure that people understand that. Because once that order becomes a final order, and if the judge denies your exceptions, then what's going to happen is that that's kind of closed off that period, and the next opportunity you would have is to actually file an appeal to Superior Court. Otherwise, once a lot of those things have been decided, they cannot be relitigated. If the judge does agree with you and finds the master made mistakes, then the case can be remanded down or sent back down to that master to either perform a new hearing, depending on the type of mistake that was made, or to just address the particular issues that were of error and to make a correction. So for example, in that situation where it was just that the master left out the tuition cost for daycare, the judge could send it back down just to correct that one thing instead of having a brand new hearing and coming up with possibly an entirely new calculation for support. So I hope this sheds some light on why it's so important to get those things done right at your master's hearing and what evidence may or may not be admissible at an exceptions hearing. If you have any questions or you've seen something else, please drop it in the comments below. If there are other topics you would like us to cover on custody, divorce, and support, make sure you put that in the comments as well. And make sure you hit subscribe and the little notification bell so that every time we drop a new video, you'll get a new notification and you won't miss anything. All right, until next time, take care.